All right, we're recording again. I can see the red dot in the upper left-hand corner. September 24th, 2024, 3:39 p.m. We were going to move into closing arguments. Ms. EIRSCHELE indicated she wants to move an exhibit in, which is ERD 052.
Correct.
You indicated, Ms. EIRSCHELE, that you believe you testified regarding, I think, your interactions with Deputy Director Kruger. Is that what you were stating? Or with Mr. Paulson?
This I reported my heart rate, my accelerated heart rate in September of 2019, and this is just documentation showing how it was elevated when I would be at work due to my work environment.
Alrighty, and then Attorney Simcox, I believe you were objecting.
That's correct. Just to the general relevance of this, I'm not certain of the purpose of this. I have no objection if she's just showing that she experienced an elevated heart rate to the extent that she's trying to show that it's part of a disability. I don't think that foundation has been established, nor is it timely, given the timestamp that are on these images as they occurred in 2019 and prior to the date we established of April 16th of 2021.
Right. Ms. EIRSCHELE, was this going just to generally show that you were experiencing the elevated heart rate at work due to the work environment, or were you trying to prove otherwise?
No.
So I will also state that it's obviously very hard to read. If I try to zoom in, it's not going to be legible because it's not a quality image. While I agree it's probably not going to be the most relevant, to the extent that Ms. EIRSCHELE feels it shows something, I'm just going to be inclined to admit it. The objection is noted on the record, obviously.
Thank you.
I will admit the exhibit. And Ms. EIRSCHELE, are we prepared to move into closing arguments?
I believe so.
All right. Typically speaking, closing arguments is not a place to add new testimony. It's also not required that you rehash every single bit of testimony that we've heard, but it is your best place to explain and to argue why you think the evidence shows proves the discrimination that you believe occurred. So you generally have some latitude here, as long as you're referencing testimony that we've heard in the hearing. It's your opportunity to argue why you think it shows that discrimination. All right.
Okay.
You can go ahead.
When I reported my concerns about the racial discrimination and mistreatment of minority participants to my supervisor, Andrew Paulson, I did so with the firm belief that these participants were protected under federal law while they were in the program's training. My actions were consistent with the protections granted by the Wisconsin Fair Employment Law, which prohibits discrimination based on race, disability, and retaliation for opposing discriminatory practices. I respectfully submit that I acted in full compliance with these protections. The National Guard Youth Challenge Program Cooperative Agreement specifically outlines the participants while residing at the residential training facility are afforded protections similar to those of federal employees, especially regarding issues like injury compensation and legal liability. For instance, if participants such as majors, police majors, had been harmed due to extreme cold, she would have been protected under the agreement's provisions. This understanding informed my belief that the participants were entitled to the legal rights and protections, and consequently, the Wisconsin Fair Employment Law applied as well. It was on this basis that I opposed the mistreatment of racial discrimination affecting minority participants in the program. Despite the participants not being traditional employees, I felt a moral and legal duty to advocate for them. I made my report in good faith, fully trusting that both the participants and I were protected under the law. I believe that my advocacy would be safeguarded under the Wisconsin Fair Employment Fair Employment A, WFEA. I'm forgetting what the acronym is right now.
Act. Some people call it the law.
Okay.
Fair Employment Law, Fair Employment Act.
Thank you. Which protects individuals from retaliation for opposing discriminatory practices. Unfortunately, after raising these concerns, I was subjected to a series of retaliatory actions, which only escalated following my request for reasonable accommodations due to my disability. Paulson weaponized my health against me, exacerbating my symptoms, and new symptoms arose. Clearly in an effort to constructively discharge me. Additionally, HR misled me, failing to accurately inform me of my rights and options. These actions compounded at the hostile work environment I faced. In retaliation for opposing the racial discrimination and requesting accommodations, my job duties were drastically altered. My work became less desirable, and my career as well as my career prospects, including chances for promotion, which were stunted. I was isolated, scrutinized, harassed, forced to adhere to special rules, and treated with hostility. My performance evaluations were manipulated, and the scores reduced, and the goals changed without notice. I was denied pay increases, merit-based awards, and eventually subjected to multiple investigations and suspensions, accumulating in my termination. Post-termination, I was further denied the benefits I had rightfully earned while working at DMA, including workers' compensation. The consequence of these actions extended beyond my professional life, tarnishing my reputation and defaming my character. The retaliation I endured was illegal and unjust, leading to a constructive discharge that was unwarranted. Before I opposed the discrimination and requested reasonable accommodations, my work environment was drastically different, characterized by more favorable and fair treatment. Under the Wisconsin Statute 111.322, and then parentheses 3 of the Wisconsin Fair Employment Act, it is explicitly unlawful for an employer to retaliate against an individual for opposing any discriminatory practice. This provision states that it's an act of employment discrimination to discharge or otherwise discriminate against an individual because of the individual opposes any discriminatory practice under this subchapter, or because these individuals have made a complaint, testified, or assisted in any proceedings under this subchapter. This statute ensures that an employee such as myself who opposes or reports racial discrimination is protected from retaliatory actions by their employer. My opposition to the racial discrimination treatment of the participants in the National Guard Youth or Challenge Academy subsequently fall subsequently within these legal protections. The law is clear. Retaliation against individuals engaging in protected activity is prohibited, regardless of whether these individuals belong to the race-based or other protected class affecting affected by the discrimination. I exercised my right under the Wisconsin Fair Employment Law to oppose unlawful racial discrimination and request reasonable accommodations for my disability. The retaliation actions taken against me included job duty changes, adverse treatment, and untimely, and ultimately my termination were not only retaliatory but also unlawful. Therefore, I respectfully assert that the actions taken against me, particularly my termination, were a direct violation of the rights under the Wisconsin Fair Employment Law. I seek justice for the significant harm caused to me, both professionally and personally, as a result for my opposition to these discriminatory practices and my request for reasonable accommodations. I urge the court to find that probable cause exists in this matter and to hold the respondents accountable for their unlawful actions. Thank you.
Right, thank you, Ms. EIRSCHELE. Attorney Simcox.
Thank you. So we're here today and yesterday for a probable cause hearing on a finding where there was no probable cause determined by an ERD investigator previously. As part of this hearing, to proceed with a hearing on the merits, Ms. EIRSCHELE was required to show that there's, quote, a reasonable ground for belief supported by facts and circumstances strong enough in themselves to warrant a prudent person to believe that a violation of the act probably has been or is being committed. That's stated under WIS Admin Code DWD 218.02. Ms. EIRSCHELE has multiple claims here. There's a claim stemming from an incident in January of 2019 in which she alleged racial discrimination that was occurring with 2 cadets at the Challenge Academy. She alleges that the employment actions that were taken and the environment created were all based on retaliation from that first reporting. Ms. EIRSCHELE has also had multiple other claims, including a failure to accommodate claim and a disability discrimination claim. As the courts previously ruled, the failure to accommodate claim is not at issue. It was not timely, and it was barred by the statute of limitations. Further, even if it were timely, the evidence has shown in this hearing that Ms. EIRSCHELE requested ergonomic adjustments to her desk, her keyboard, her mouse, and those were provided to her based on the information from her doctor. I'm going to deal with the 2 claims separately, the retaliation and the disability discrimination, because the retaliation claim, there's first a threshold question. In order to be protected from retaliation under the Wisconsin Fair Employment Act, Ms. EIRSCHELE would need to show that she objected to conduct that is covered by the Wisconsin Fair Employment Act. It's a legal question for the judge to determine as a threshold matter whether Ms. EIRSCHELE's conduct in reporting the alleged discrimination in January of 2019 and any other conduct that she alleges occurred with cadets is actually covered by the Wisconsin Fair Employment Act. I submit that 32 USC Section 509 National Guard Youth Challenge Program of Opportunities for Civilian Youth makes clear that cadets at the Challenge Academy are not employees and therefore not subject to the Wisconsin Fair Employment Act. While it lists multiple areas in which cadets may be considered employees, these are for limited purposes, including workers' compensation injuries and for tortious conduct. Ms. EIRSCHELE's complaint, therefore, was not covered by the Wisconsin Fair Employment Act because the cadets are not employees under the Act. But even if they were, Ms. EIRSCHELE would have to show that she engaged in protected activity that's covered by the Act, which I've argued that she cannot do, and then that she suffered adverse actions because of her reporting there. Retaliation is all about what one can show with causation. And as one of the factors in which retaliation claims are analyzed is temporal proximity to the act. We've heard testimony over the last 2 days that the original reporting occurred in January of 2019. Ms. EIRSCHELE was not terminated until August 9th of 2021. She went through a series of progressive disciplinary actions commencing on December 16th of 2019, when she was issued a 1-day suspension leading to her termination on August 9th of 2021. Basically, as the time goes out further from the reported acts, even if they were covered under the Wisconsin Fair Employment Act, which they're not, Ms. EIRSCHELE's connections to the actual reporting and the adverse action that she experienced is not present. We've heard 2 days of testimony in which Ms. EIRSCHELE failed to connect the dots as to why any of the actions taken were actually retaliation or discrimination rather than the result of legitimate non-discriminatory reasons provided by the employer. In each action that Ms. EIRSCHELE experienced from the employer, the 1-day suspension, the 3-day suspension, the 5-day suspension, the termination of her employment, Ms. EIRSCHELE was provided with substantial due process in which there was an investigation of the allegations, there was an investigative report, and then there was a letter issued with the findings of the investigation. At each time, Ms. EIRSCHELE was eligible to appeal the decision, and as we established in the evidence, she did this on multiple occasions. She went through a step 1 appeal with the agency on multiple of the disciplinary actions, none of which were overturned as a result of the step 1 discipline, and she went through a step 2 appeal of the determinations in which the Department of Administration reviewed the actions and determined not to overturn the actions. Many of Ms. EIRSCHELE's myriad complaints of retaliation and adverse actions aren't actual adverse actions, or it's really difficult to define what the actual adverse action was. Through 2 days of testimony, it's difficult to figure out, other than the actions that I've listed, the 1-day suspension, the letters of expectation, the 3-day suspension, the 5-day suspension, the evaluation, the termination, those could all potentially be adverse actions. And I would argue that they would be considered adverse actions. Each of the respondents' actions in these cases was based on legitimate non-discriminatory reasons, not on any retaliatory or discriminatory basis. But many of the other adverse actions that Ms. EIRSCHELE complained of aren't actual adverse actions that are covered under the law. She complained about many different things. A running theme was that she felt that her agency was not following policies of the Wisconsin Human Resources Handbook. Those concerns could and would be addressed by any appeal of the disciplinary action, but these were all upheld. One of the actions went as far as to work and was upheld. Step 1 and step 2 appeals of these actions showed there was no impropriety, and they were upheld. So with respect to the retaliation claims, it's difficult to determine what the causal link was between the actual reporting here and instead of trying to take the feedback from her supervisors, and over the course of almost 2 years of progressive discipline and feedback from their supervisors, Ms. EIRSCHELE chooses to believe the least generous interpretation of her agency's actions at all times, that it had to be retaliation or that it had to be discrimination. She's provided no evidence that it was either retaliation or discrimination. In summary, Ms. EIRSCHELE has not shown probable cause for a hearing on the merits on her retaliation claims, both because her conduct was not covered under the Wisconsin Fair Employment Act, and even if it was, she hasn't established an appropriate causal connection between the actions that were taken and, between her protected activity and the adverse actions that she alleges. there's no evidence to find probable cause based on the retaliation claim. When it comes to the disability claim, Ms. EIRSCHELE would be required to show a number of things that she did not show in the evidence. First, she hasn't shown that her employer was aware of any disability other than arguably the fibromyalgia, where she had requested reasonable accommodations. As we've established, that claim was dismissed as untimely, and she did receive the reasonable accommodations for her disability. These other many concerns, these many conditions that Ms. EIRSCHELE has alleged, she's provided no evidence that she has a diagnosis, a formal diagnosis, or that her employer was aware of the diagnosis here to support her belief that they discriminated against her on the basis of her disability. Ms. EIRSCHELE would need to show, in order to prove her case and to show a probable cause, she'd have to show that she's a member of a protected class, disability is one, that she fulfilled the functions of her position, and that she experienced treatment that was different from her peers who were not a member of that protected class. She has not shown that. She has not introduced any credible evidence about how any of her comparators within her office were treated and how it differed from her based on her disability. All of Ms. EIRSCHELE's evidence is based on speculation. In the 2 days of testimony, the record is filled with instances in which Ms. EIRSCHELE was stating at the time of writing that she doesn't know for certain what happened, but that she suspects it might be retaliation or discrimination. Ms. EIRSCHELE's suspicions were never verified. There's no credible evidence to believe that there was anything other than the employer's legitimate non-discriminatory reasons for taking these progressive disciplinary actions. This was not a short or easy process. The employer took over 2 years to work, or excuse me, approximately 2 years to work with Ms. EIRSCHELE on correcting these deficiencies. They didn't skip any steps in between. And in fact, when they could have bumped things to a more severe form of discipline, she was instead issued 2 letters of expectation, which did not advance her likelihood of getting terminated. They issued a 1-day suspension, then 2 letters of expectations before issuing a 3-day suspension, a 5-day suspension, and a termination. The contemporaneous documentation of Ms. EIRSCHELE's performance evaluations, the emails with her supervisors and her colleagues all show that everybody was working with Ms. EIRSCHELE to try to help her improve on her issues of accountability and communication. But even if Ms. EIRSCHELE could have established her prima facie case of disability discrimination, which she didn't, once the employer articulates a legitimate non-discriminatory reason for the actions taken, the burden shifts to Ms. EIRSCHELE to show pretext, which in layman's terms, the employer is lying. It's not enough for Ms. EIRSCHELE to allege that the decisions were unwise or that they should have taken a different course of action. She would have to show evidence that the employer was actually lying about the stated reasons for their actions. She has produced no evidence of such. I want to speak briefly about some issues of credibility with the testimony that came in. I fully understand the difficulty of being a pro se litigant and understand that Ms. EIRSCHELE was working as hard as she could to present relevant evidence there, and I commend her for her efforts in doing so. One thing that I would like to point out, however, though, is that when it came to time of talking about adverse actions or what took place, Ms. EIRSCHELE testified repeatedly that she could not remember precisely what happened because she said that it was all a blur at that time. The documentary evidence that is in the record doesn't lie. Ms. EIRSCHELE has very little memory of what took place during then and struggled to remember details. There was also a credibility issue with one of the witnesses. Excuse me, Sarah Chapman came in and answered questions in which she clearly wanted to talk about her own experiences, in which she believed that the agency had wronged her. She said little of relevance to Ms. EIRSCHELE's many claims in the case. As pointed out in the cross-examination, Ms. Chapman was recently terminated from the agency herself based on falsification of records just in July of this year. This raises serious issues of credibility. There's many adverse actions that were alleged here. I submit to the court that all of these have been firmly discussed in the record and in the evidence that was introduced through Ms. EIRSCHELE's testimony and cross-examination and the materials submitted here. When it came down to many of the adverse actions that Ms. EIRSCHELE was trying to prove, including the training requests that focused on Puerto Rico and Hawaii, the testimony that came in was people didn't have any personal knowledge about the other people who had been approved in similar circumstances. Ms. Chapman discussed that she had approved travel requests over the period of 6 years, but admitted that she didn't know the reasons why certain requests were approved and Ms. EIRSCHELE's request was denied. She didn't have access to personnel records. Likewise, Ms. EIRSCHELE doesn't have access to other people's records. She has no evidence to state that she was treated differently or that it wasn't a legitimate reason that her progressive discipline and coming off of a 5-day suspension and a negative performance evaluation was not a legitimate basis to send Ms. EIRSCHELE to Puerto Rico or Hawaii, especially when neither of those trips was going to adequately address the areas that had been identified where Ms. EIRSCHELE might benefit for additional training. I won't go through each of the adverse actions, but I will just state that this case has been a difficult case to follow for everybody at DMA. The record is very clear that when Ms. EIRSCHELE was reporting concerns, the emails show that people were asking Ms. EIRSCHELE, what specifically are you alleging? Can you give me details? She discussed yesterday extensively how she believed that somebody had engaged in sexual harassment by telling off-color jokes. The emails from that time between her and Stacy Meyer show Stacy Meyer reaching out saying, give me more information, tell me what happened. It's at that point that Ms. EIRSCHELE routinely failed. There's no connection between the adverse action that's alleged and any sort of retaliation or discriminatory conduct. There are pages that we introduced where pages and pages of adverse actions that Ms. EIRSCHELE has alleged, in addition to most of those not qualifying as adverse actions and probably going to an argument of overall hostile work environment. Again, the evidence simply does not support that there's any link to Ms. EIRSCHELE's alleged disabilities or retaliation for engaging in for reporting discrimination that's covered under the Wisconsin Fair Employment Act. I thank everybody for their patience in this hearing, and I have nothing further.
Thank you, Attorney Simcox. Is there anything else the parties think we need to address on the record before I stop the recording? You're muted, Ms. EIRSCHELE, but I think you're saying no.
No, not at this time.
Attorney Simcox, was that no as well?
No from me. Thank you.
All right, thank you. I'm going to stop the recording and close the record.